My name is Mary Power. I've had the privilege of introducing Estelle Dehon. She has just completed the mammoth task of reviewing the last 12 months of case law on topics such as climate change, net zero by 2050, EIA, habitats, conditions, Section 106s, SIL, policy interpretation, amongst others. Your objective was to draw out the practical application of these cases to day-to-day practice. One of the startling policy objectives of the government's commitment to net zero by 2050 is one of your themes. Do you want to just elaborate on that whole theme and where policy is going?
Yes, thank you very much, Mary. It's one of the things that I think is most exciting in planning. And the first area where I think net zero will have a significant impact will be for local authorities thinking about their local plans, thinking about the climate change policies within their local plans, and especially those authorities, and there are over 200 of them now, that have declared a climate emergency. Once the declaration is done and everybody, well, not everybody, but many people have their celebration, the authority then sits there and says, well, what does that actually mean? And I think net zero and what indeed the Climate Change Committee has started to say about the types of planning policy that we need to achieve net zero, which are very significant, I think local authorities will be looking at that. And it can be things as nitty-gritty as how we insulate our houses and how we insulate our current stock, and then what we do with our new buildings and whether we're building green buildings, for example. And when it comes to development, I think there is going to be a greater assessment of the carbon impact of development in all its forms. And that's very tricky because all development will have carbon impact. And obviously net zero doesn't mean no carbon and no methane. It just means that it's as limited as possible. And we're all going to be looking in how we devise development, I think, about how we can start to minimise. And we're going to see more infrastructure related to electric vehicles. We're going to see more emphasis on public transport. We're going to see more wide-scale infrastructure projects related to net zero. I think it's very exciting.
Can you give us any insight into the impact of the Paris Agreement?
Yeah, I can. So this was one of the kind of nicest nerdy law bits of the reading that I was doing for this particular paper. And the Paris Agreement was put in place, agreed in 2015 and came into force in 2016, which really was the basis for the commitment across the globe to keeping temperatures, the global temperature rise, well below 2 degrees, but ideally to 1.5 degrees. But that's an international obligation. And so the Paris Agreement has started to make its appearance in the United Kingdom, both in the planning inquiry sphere, where in fact it has been given emphasis as a material consideration, and also in court. And the court cases that deal with the Paris Agreement, indeed, those arguments haven't got very far. And the arguments aren't the Paris Agreement applies directly, but that the Paris Agreement is some type of policy material consideration. And the courts have been highly sceptical of that argument. But that was before we had net zero and the Climate Change Committee's recent report. And I think it will be fascinating to see in the Spurrier case, which is coming to the Court of Appeal really soon, how that makes a difference and whether the Paris Agreement is explicitly going to be recognised as a material consideration in planning decision making.
Thank you. Over the past 5 years or so, promoters, developers have used the Para 11, as it is now, of the MPPF to reflect onto the tilted balance in order to get schemes through. You did touch in your presentation on your thought that that is less relevant. Do you want to just expand upon that? And I think you mentioned the Paul Newman case, which has only just come out as well, which is not yet in your paper. Do you want to expand a little on that?
Sure. So I think just anecdotally chatting to people, I think developers are saying that kind of golden arrow of being in the tilted balance is less and less helpful to them. And they're finding that, in fact, it's not something that they necessarily are trying to push for, or that even if they are in the tilted balance, even if they are in an area with, a 3-year, a 2-year housing land supply, situation, that's not necessarily getting them over the line. And that in fact what inspectors and decision makers are more and more looking at are things like landscape impact, environmental impact, impacts on human beings and how we live. And so the Paul Newman case is interesting because it was, I think, one of the last straws for trying to position yourself within the tilted balance, because it said explicitly, so long as there's some old policy that is applicable and that is saved and that is not out of date, then we're not going to be in Para 11 territory. So I think it's becoming more and more difficult to get even into Para 11 territory.
Thank you. Is there one particular case that's caught your eye over the last 12 months that sort of reflects on your particular passion for environmental law?
There is, and it's not one of ours. It's the Agenda case, which it was in the Dutch Court of Appeal and it's gone to the Dutch Supreme Court, and we await a decision. But that, I think, is fascinating because it brings together human rights and climate change, which is something indeed that the Paris Agreement does. And it sets out explicitly the step-by-step how the climate change, the potential impacts of climate change on people's lives engage Article 2, which is the right to life, and how the impact on people's relationships and people's physical integrity engages Article 8, and how that may well be deployed in a court setting to push the ambition of government and to push the ambition of policymakers. Now, these courts in this country, our courts, have not necessarily been greatly open to human rights arguments, but they may. And I think the Agenda case is interesting in that setting.
You finished your presentation about the challenges of net zero, but also the opportunities. Do you want to just expand a bit further on net zero and the challenges we're going to face?
Yeah, well, one of the interesting opportunities that I think isn't really getting as much press as it should is the role that hydrogen is going to be playing in both our heating system and our transport system pretty soon, by 2030, I say. And that has a lot of potential for planning, both in terms of how our transport infrastructure is structured. So if you're doing a large-scale development, you need to be thinking about your cars not just being electric, but also being hydrogen-powered, and the potential for them to be able to fuel with hydrogen. And then for industrial development, the very clear message is industry has to be powered where it can't rely on renewables because it needs a large sustainable power supply. That's going to be hydrogen. And our system is going to need to be amended and developed to be able to support hydrogen power for industry. And that, I think, that's very exciting. And those of us in the planning world should be embracing that.
Thank you very much, Estelle. Thank you.